We'll call the next case on the docket, State of Kansas versus Darren Hirsch, 116356. Counsel, as you approach, I'll explain that the Chief Justice has been caught on a legislative matter. As soon as he's finished with the phone call, he'll join us. So.
May it please the court?
Yes.
Sam Shire appearing on behalf of the defendant appellant, Darren Hirsch. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is reserved. Thank you.
Thank you, Your Honor. To briefly state the facts for the audience, this is an appeal from a jury trial which resulted in multiple convictions which relate back to an alleged incident of domestic violence which was alleged to have occurred in March of 2013. Mr. Hirsch appealed his convictions to the Court of Appeals, raising multiple trial errors. Court of Appeals found merit in one of those issues and therefore reversed Mr. Hirsch's aggravated assault conviction. However, the Court of Appeals affirmed the remainder of the jury trial's convictions. Mr. Hirsch then petitioned to this court, and this court granted discretionary review. And that is how we got to where we are today. Moving to the legal issues, there are 5 which are raised in the petition for review, and it's my intent today to focus primarily on the first 2 issues in the petition. That will be the Brady issue and the multiplicity issue. Moving to the Brady issue, what we have in this case is a mid-trial disclosure of a law enforcement report which attributes a statement to Mrs. Hirsch in which she is said to have stated that Mr. Hirsch assaulted her in the downstairs basement of their shared residence. That statement differed from her trial testimony that the assault occurred in an upstairs bedroom.
Let me ask you, though, I guess I want to be very precise on the facts here. The law enforcement report that we're talking about is sort of hearsay once or twice removed, right? It doesn't attribute a statement by someone who talked to her or heard her say it. It's somebody saying that she might have said this or reported that it was said, but it wasn't the person in the report, and it wasn't the person that was making that was being quoted, right?
I mostly agree with you, Your Honor.
So let's get precisely
Yes.
what the statement, who said what to whom.
Yes. Mrs. Hirsch, according to the report, Mrs. Hirsch made a disclosure to her boss at work, Ms. Schwartz. Ms. Schwartz then relayed that to Deputy Reed, and then Deputy Reed relayed that to Undersheriff Green. Where I would disagree slightly with your view of this, Your Honor, would be that I'm not sure that this would have been hearsay.
Yeah, I'm not really trying to make a legal evidentiary hearsay thing. I'm talking about it being multiple times removed.
That's correct, Your Honor.
Okay.
But at any rate, that is the nature of the evidence. And I don't believe that there is any dispute at any level in this case that this would have been impeachment evidence within the meaning of Brady.
But that's the one thing in the disciplinary report that came to light during trial that was inconsistent. That's the one thing you're relying on, the basement versus the upstairs bedroom, right?
Yes. Okay. That is the distinction. Where the Court of Appeals began to hold that we had not established a Brady violation was on the second element of a Brady claim, the suppression of evidence element. And the way that the Court of Appeals viewed this is that because the prosecuting attorneys in this case were not aware of the existence of this report until it was literally brought to trial by a witness, that prosecutors in this case were not suppressing evidence. And what we tried to make clear in the petition for review is that we are not taking issue with that factually. The record is very clear that the prosecutors in this case did not suppress evidence. The problem with the Court of Appeals' analysis is that for Brady purposes, the knowledge of law enforcement is imputed to the state. And in this case, I believe Under Sheriff Green, having drafted his law enforcement report, was very clearly aware of its existence, and therefore that knowledge should have been imputed to the state for Brady purposes. In its briefing to this court, the state, I believe, is taking a different approach than the Court of Appeals in arguing that there was no suppression. And in the state's view, there's no suppression because this evidence was disclosed to defense counsel on the last evidentiary day of trial. And I'm not sure, as I'm reading the state's briefing, that the state is necessarily pressing the point that it is impossible to have a Brady violation when evidence is disclosed in the middle of a trial. But I believe that the state is arguing that in this case, evidence was disclosed in time for defense counsel to have made use of it. And I would disagree with the state on that point. I think that if this court looks at the motion for new trial, which was filed in this case, it's clear that defense counsel did not even have a recollection of having received this report during trial when he filed his motion for new trial. So that, I believe, is a very strong indication that in the middle of this trial, he was not able to adequately review the document, locate the impeaching statement within the document, and make use of it.
How long of a document are we talking about?
It's a 2-page document, Your Honor, and the impeachment statement is one sentence. It's buried in a 2-page document. And I think it's reasonable under that circumstances that in the middle of a jury trial, that counsel wouldn't have been able to pick that out and immediately ascertain the significance.
And really, the impeaching evidence is in the basement of their residence as opposed to an upstairs bedroom in their residence. It's those 4 or 5 words that's critical in your mind.
That's exactly
that
right.
allows the impeachment of inconsistent statements or however you would approach it.
That's exactly right, Your Honor.
That's the use the defense might have made of it had they had it sooner. Let's assume for purposes of argument that you're right about the Court of Appeals having a legal error in their Brady analysis, and that you're right that this was produced too late. Let's just assume those for purposes of argument. I'm interested in hearing what you have to say to us today about why this is prejudicial, given that the complaining witness had been inconsistent over time and admitted she'd been inconsistent over time in many of the particulars, whether the events occurred at all, etc. How does this one item make a difference?
I think it makes a difference, Your Honor, because you're correct in noting that there were multiple recantations in this case. But if this court looks at those recantations, those are mostly, really all, Mrs. Hirsch saying that the act of domestic violence never even happened. So that's different than the type of inconsistent statement in this police report. This police report can't be explained away on the theory that Mrs. Hirsch was motivated to keep her ex-husband out of legal trouble. This is just a statement that is difficult to reconcile with the testimony that she gave at trial, more indicative of somebody who is unable to keep their story straight than somebody who is recanting for other motivations. The other thing that I would note is that this case was, in its essence, a case about whether Mrs. Hirsch's statements could be viewed as credible enough to support a criminal conviction, multiple criminal convictions, because there was no forensic evidence, really. There was no third-party witnesses who directly witnessed the alleged incident of domestic violence. There was no confession in this case. So really, the jury had to accept Mrs. Hirsch's testimony and out-of-court statements. And the jury was, in fact, did seem to be on the fence about whether Mrs. Hirsch was credible beyond a reasonable doubt, because we know from the jury's verdict that it did not feel that the state had proven its intimidation of a witness charges, which, if the jury had credited Mrs. Hirsch's testimony, those clearly would have been supported by the evidence. So I think we have a jury that could have gone either way, and this little bit of extra impeachment could have been the difference in the jury's verdict. So we would ask this court to find that this is material evidence and that a new trial is warranted. Moving on very briefly to the multiplicity issue, what we have in this case is testimony in the light most favorable to the state that Mr. Hirsch is holding a gun and making a statement to Mrs. Hirsch that, quote, "it will all be over soon." Mrs. Hirsch then immediately responds, "don't let the boy see me like this." And Mr. Hirsch then immediately responds, "they will be going too." And the Court of Appeals in this case conceded that, and I think it was required to, based on this court's case law, that you don't get multiple criminal threat convictions because there are multiple individuals being threatened in these statements. What the Court of Appeals opinion seemed to indicate to me...
But isn't the case law about a single threat made to a group, as opposed to a threat made to this person and then a second threat made to this person? Because these threats were different from one another. They were separate. They were only separated by one statement by her. I grant you that. To me, that sounds like your stronger argument that there was no fresh impulse. But, I mean, really, there were two different targets, two entirely separate targets. Her in the moment, kids in a few minutes. Right?
I suppose that's correct, Your Honor.
That distinguishes them from the earlier case law, doesn't it? Where we say you don't just count the number of victims, the number of intended victims of a single threat. That's what case law is, right?
That's
so this
the
is
case.
Distinct in that way.
Yes, that's the question here is whether there's multiple threats.
Right.
And to me, the Court of Appeals answered that this is a question for the first prong of a multiplicity test. Mm-hmm. The first prong is whether
there's different conduct.
And the Court of Appeals decided, correctly I believe, that this is unitary criminal conduct. So having reached that decision that really we just have one threatening episode here, I think that the Court of Appeals on the second prong of the multiplicity test would have been compelled to reverse because we are dealing with one statutory crime, assuming that there is only one threatening episode. And the way I guess that I read the Court of Appeals' opinion is that they are indicating that there's a unit of prosecution inherently for every threatening statement an offender makes. And I would disagree with that interpretation of statute. The unit of prosecution, according to this court, is one communicated threat. And I think that a communication, particularly when considering the rule of lenity, this court should interpret a communicated threat as something which may be inclusive of multiple statements. So for that reason...
If you're wrong, if the Court of Appeals is wrong and you're wrong in agreeing with them on the one act analysis under the first prong, then we don't even get to unit of prosecution, do we?
That would be correct, Your Honor. However, I would note that the state has not filed a petition for review in this case. And the Court of Appeals did very clearly find that the first element of multiplicity violation weighed in Mr. Hirsch's favor. So I'm not sure that that question would be is preserved for this court to consider even.
Okay, thank you.
Your Honor, may I please have a moment to conclude my argument?
How about 30 seconds?
Thank you, Your Honor. For the reasons argued in the petition for review, we would respectfully ask this court to reverse all of Mr. Hirsch's remaining criminal convictions and remand this case for a new trial.
Do we have any questions? Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm actually planning on focusing on Brady also, but also the prosecutorial error. And I would stand on my briefing on the multiplicity unless this court has any questions.
I have a question.
Okay.
I'd like you just to address that last point of your opposing counsel. He said that you had to cross petition in order for us to address the Court of Appeals ruling on the conduct being one act.
I think that even if the conduct is one unitary act because there's no fresh impulse, there's still two threats. And that's the argument I made in my brief, and I would continue to make that argument.
You think you win on unit of prosecution even if we say there was only one act?
Correct, Your Honor.
So, our case law is that if you shoot multiple times at a car that has several people in it, that's only one aggravated assault or one discharging at an occupied vehicle, right?
Correct.
But if you threaten, I'm going to kill the driver, well, you better not, and I'm going to kill the passenger, and then they shoot at, they're guilty of two criminal threats, but only one ag assault when they shoot. I mean, that's counterintuitive to me.
It's per threat, so there's two separate threats there is the argument.
Okay.
Turning to Brady, counsel did summarize this correctly. What essentially happened was during cross-examination, the prosecutor noticed that the defendant had a piece of paper in his, or I'm sorry, that Sheriff Green had a piece of paper in his hand, and the prosecutor basically asked, hey, what's that? And they realized they had never seen that piece of paper before. It was a misconduct report into Deputy Reed's failure to report what had happened when he was told by Schwartz about this case. The prosecutor kind of made a pretty big deal out of the fact that they hadn't seen it before. They immediately break, they go to get copies. Defense counsel at this point should be on notice that prosecutor didn't have this report, so you didn't get it. You might want to read it. It's only 2 pages. They then go on to present additional witnesses, the defense does, and then they break for a weekend. So they have the actual break in
Didn't
time.
though the subject of hadn't people already testified prior to that time in the trial? I mean, you said they break for the weekend. Didn't the state already have their evidence put on?
The state had already rested at this point. This is during defense's case.
So
With-
how was the defense supposed to make use
That's
of
my
it?
question. How do you make
Were
use
they
of it?
supposed to recall the complaining witness?
They could have done that. They could have asked for a recess. They could have asked to subpoena additional witnesses. Schwartz was actually the person who made the statement to Reed, was under defense subpoena.
But hadn't she already testified?
She testified in the state's case, but she was under defense subpoena for the defendant's
subject
case.
to impeachment during cross-examination based upon this report. I mean, that's kind of the point. I would think that's the point.
Well, correct, but they could still recall Schwartz, who was under subpoena, and ask her the same thing. In fact, we still don't know what would have happened had they attempted to do anything, because they didn't put Deputy Reed on, they didn't put Schwartz on, they didn't put Candace on at the motion for new trial to tell us what they would have done with this evidence. We don't know that, which I don't think meets their burden of proving that it's material. But going back to whether or not they could have actually used it, they didn't ask for anything to be able to use it, which is what they should have done. They should have reviewed the report. If it was really that important that they think it would have further impeached something that was so crucial they needed to present it, they should have asked the district court for more time, have the state even recall the witness so they could ask a cross-examination question. They did absolutely nothing. So they basically, but they had time to, and they were able to, and this court should find it wasn't suppressed for those reasons.
Are you conceding that the state should be charged with knowledge of this report?
I think the case law basically makes me concede that, although
Is that true in the context of a disciplinary report?
I'm not sure.
Okay. And I guess if you've conceded the point, then you've conceded
Well,
it. But
I'm
of those, I'm just wondering if there's a layer of confidentiality or if that makes any difference in a Brady
I
context.
would like to think that the fact it's a disciplinary report makes a difference, and the fact it's defense witness should make a difference. The defendant can get reports from their own witness. The state didn't suppress their ability to do so.
Why would the sheriff have brought that document with him on the witness stand?
I'm sorry?
Why would the sheriff have brought that document with him on the witness stand if it was being treated solely as a disciplinary report?
I do not know. My best guess is that was the sheriff's really only interplay in this case was investigating Deputy Reed's failure to report. He didn't do anything else in this case. So that was his only connection to the case. That's why he brought that report. But I don't know.
The one fact that your opposing counsel is focusing on, though, that diverges from the story, the basement versus the upstairs room, you're not disputing that that would have been possible impeachment information.
Correct. I don't think it's particularly strong, and in fact, I think it's so weak it's not even material at all. But I agree that it could be
And
impeachment.
Brady materiality is something
Right.
in addition to materiality as we
Correct.
ordinarily understand it.
Sorry.
Yeah.
Yes, Your
Okay.
Honor.
Well, do I recall the facts that the reason there weren't any witnesses was this happened upstairs supposedly, and like the child and maybe someone else was in the basement? Weren't there other people in the house at the time, but they weren't on the same floor?
The child, I think, was asleep. I don't think the child was in the basement. What happened in the basement is originally Darren Hirsch and I'm forgetting the law enforcement, she's now a trooper, that he is married to, I think, or they're dating. The girlfriend that wasn't supposedly the girlfriend. They were in the basement.
Okay.
The wife calls down, says, get out, essentially, take your girlfriend and leave. And that, the non-girlfriend left, and then this all happened. And then she returns to the basement at the very end of all of this, because that's where they have their security cameras to make sure he doesn't come back, because she's terrified at that time. So the basement is mentioned throughout the trial.
Okay, yeah, that's what I was recalling.
Okay.
But the actual battery or assault was supposed
Right.
to have taken place upstairs.
Upstairs, yes, he came
And
upstairs.
Was there one child home or two children?
I do not remember at this
Okay.
time.
But they were in another room
Yes,
separate
there's.
from the one where the attack took place.
I don't believe there's any allegation that the children witnessed any of this,
Yeah.
or at least we didn't call them as witnesses.
Haven't seen anything. Okay.
Right.
Can you talk about materiality, that specific Brady materiality for a moment? If you were to fail to prevail on your this wasn't suppressed argument because it came in during trial and they had enough time to work with it, I'd like to hear you address that.
I think the Court of Appeals essentially got it right, and Your Honor alluded to it. She was impeached throughout this entire trial. This one particular piece of evidence, which is pretty weak because it's multiple layers of hearsay at this point. We don't know if Deputy Reed got it wrong. We don't know if Under Sheriff Green got it wrong when he reported his report wrong. We don't know exactly what happened. This is not strong evidence that Candace herself actually said this. This is Schwartz reporting something. So I don't think that's at all, at least Brady material. And for the same reasons that we argue basically prosecutorial error is not reversible, there is corroborating evidence here. Candace was seen afterwards by a trooper and his wife. They saw the bruising. That corroborates her credibility. Her story, her version of the facts was relatively consistent of when she wasn't recanting. She said it always happened upstairs. There's actually no evidence to show it happened anywhere besides upstairs. That wasn't really a point of the trial.
So is it opposing counsel made a distinction between her recantations were simply, I don't want to get my husband or ex trouble into legal trouble, versus just inconsistency here on where this occurred?
I agree that her recantations were mostly, it didn't happen. It was just a verbal fight, or it didn't happen at all. It wasn't different details, but I don't think that makes this material. I still think in light of all the evidence that was presented and the impeachment that already occurred, this would not have made a difference at all. Especially when it's not Candace herself saying the statement. It's report to report to report. Turning to the prosecutorial error harmlessness, I would admit we did not cross-petition, so I'm stuck with the finding that there was error. But I do think it was, in the scheme of things, a very weak error. This was sandwiched in a discussion of the evidence itself. If it had been stated a different way, it probably would have been proper. The comments were in the midst of an argument that focused on the evidence in the case. The jury heard before and after challenge comments that it was their duty to determine the weight of Candace's testimony. They heard you get to decide the weight and credit to be given to the testimony of each witness. I ask you to consider the weight and credit of each witness and decide the facts. It's one statement in 61 pages. It was a minor aberration in the trial. The prosecutor made the statement when she was discussing Candace's motivation for coming forward with the story. The defense had the chance to rebut the argument because this was made during the prosecutor's first statement. And he heavily attacked Candace, the defense heavily attacked Candace's credibility. The prosecutor again repeatedly reminded the jury of their duty to determine credibility. In rebuttal, she reminded them again. The jury was told statements of counsel aren't evidence. The prosecutor told the jury to rely on the evidence to find the facts. And in light of the acquittals, the jury just, as defense counsel sort of sorted, the jury didn't blindly believe Candace was telling the truth. They acquitted on a few charges. And again, the evidence was substantiated. 2 witnesses saw the bruising on Candace, and she told her employer the next morning when she appeared kind of disheveled at work, that she had been in a fight with Darren. Oh, and then I forgot about my prosecutorial error attempt to change the standard argument. You heard me attempt to do so in the judicial misconduct this morning. It's basically the state's position that the defense should have to object during closing argument to get the harmless error burden, or for the state to have to prove the error beyond a reasonable doubt. I think this would encourage more prosecutorial error arguments to be resolved at the district court level. Here, if there had been objection, I think it would have been pretty easily fixed, rather than basically us getting to read this for the first time without really knowing the inflection that the prosecutor used, because it's certainly possible one inflection would make it way worse and another inflection would make it not as bad. So those are the reasons I think objection should be required, and you should do something more akin to what the federal court does in the plain error, not totally a plain error standard, but at least make, when there is no objection, the defendant bear the burden of proving the harmlessness beyond a reasonable doubt. Unless there are any further questions, I'd ask that the convictions in this case be affirmed.
I have a quick question.
Yes, Your Honor.
Do you know of any case law that is analogous to this situation where, arguably at least, you have multiple threats made to one person, as opposed, and the threats may be directed at other people? We've done the opposite, where we've had one threat at multiple people. This, at least arguably, to me, presents the flip side of that coin.
Right. It is the flip side on what constitutes one threat. If there's
so let's
between
just
the
explore that with me a little bit.
Okay.
If we accept your argument that there were 2 threats here, was there only one victim?
Well, there were 2
Who were the victims?
I think you just have to have one person hear it. But the first threat was against Candace.
Right.
And the second threat was against the children. So there are 2 different...
But only one person was placed in fear.
Right. Candace was still the same, so she would be the victim that was placed in fear. But I don't even know that the victim has to be placed in fear for a criminal... I'm trying to remember the criminal...
I think the statute does require that.
I think you're
communicated well. It maybe does. They don't have to actually be in fear, but it has to be communicated with the intent to place another in fear.
Correct, because I think there are some where it's been like a telephone conversation where the cop that heard the threat, or actually I can go out of one of our office. They called our victim witness person and said they were going to blow up some county courthouse. She may or may not have. She was not the person being threatened, but still had the fear and had
so if the only person being that the defendant intended to place in fear was Mrs. Hirsch, doesn't that look an awful lot like just one threat? I mean, no matter, I'm gonna do this and I'm gonna do that and I'm gonna do the other thing, and it's all intended to put her in fear.
I agree with it. Now I'm
Do you
seeing.
get to parse all that out, and each one of those is a separate threat?
I think in most cases it will be cleaner because there will be a better break in time to allow us to prosecute multiple threats if indeed there are multiple threats. I think the closeness in time is not a factor in the state's favor here, especially since I didn't cross petition. But I do think, going back actually to the not cross petitioning, this is still a matter of law as you try to attempt to fly the Schoonover test. So despite my cross petition, you can still say there was a break in time here as you're trying to figure out how criminal threat works. But yes, the fact that there's only one person that heard the threat, which is how it becomes a criminal threat, I don't know that that's
She was only placed in fear one time.
I don't know that I agree with that entirely. It's one thing to be told you're going to die and another that your children are going to. Okay. It's two different levels of fear, I think. And I think he made them with the intent to really cause her to be terrified.
But you say it makes a difference that she made a short statement in between?
Right.
So you would concede that if he had said, I'm going to take care of you and everyone else in the house.
Right, that would go...
At the same time, that'd be one...
That'd be one threat. It's one threat, multiple victims. The courts have already held that. It's the... Yeah, so I need that separation.
Do you have any further presentation?
No, Your Honor.
Any more questions? What are you asking us to do?
I would like you to affirm the convictions in this case.
Thank you, counsel.
I'd like to address prosecutorial error very briefly. I would concede that this is probably not the most egregious prosecutorial error that this court has ever seen. But I also don't believe that it was an insignificant error. What we have here is a representative from the Attorney General's office of the state of Kansas telling jurors, personally vouching for the credibility of the complaining witness, which was very significant in this case because, as I stated when arguing Brady, this case really boiled down to whether the jury felt that Mrs. Hirsch was credible enough for the state to have proven its charges beyond a reasonable doubt. So when a representative of the Attorney General's office is willing to put their thumb on a scale by saying that I can personally attest that she is telling the truth, that's pretty significant in a case like this. And I would also just note that if this court did get to cumulative error, I think that this particular prosecutorial error does play in with the Brady issue because both of these issues affect how a jury would have viewed Mrs. Hirsch's credibility as a witness. So when you put those two errors together, along with the jury recall issue, which I will not get into unless this court has questions, but when you put those all together in a credibility case like this, I think these are errors that matter quite a bit.
Well, we can't add in the recall if there wasn't an error in that. And defense counsel, or neither counsel or the judge specifically asked the panel whether they had suffered domestic violence, correct?
That's correct, Your Honor.
And so you're saying that it was juror misconduct not to offer something that they wouldn't necessarily know was germane or was required to be disclosed. How are they supposed to know to disclose something if they're not asked that question?
Your Honor, the argument that we would make in our petition is there are some instances where prospective jurors can very safely infer from the tenor of voir dire that defense counsel and the prosecutor would like to receive information. This was very clearly conveyed throughout voir dire that this is a case about domestic violence. And the parties, the prosecuting attorneys and the defense attorneys.
Which very clearly would indicate that defense counsel needs to ask that question.
Well,
That's the problem here. That's the problem, that the question that begs to be asked in a domestic violence case was not asked.
It should have been asked, Your Honor, and I wouldn't dispute that. But I do think it can be inferred in some circumstances, and I believe this case is one of them. But again, just to cut back on cumulative error, even just considering the Brady issue and the prosecutorial error issue, I think that we have established that Mr. Hirsch did not receive a fair trial. And for that reason, I would respectfully ask this court to reverse all of his convictions.
Any questions? Thank you, counsel. We thank you both for your arguments this morning. The court will take this matter under advisement.